Members, we have a quorum. So I call to order this meeting. Information papers issued since the last meeting. Will members please note that after the regular meeting on the 19th of December 2018, the panel altogether received 4 information papers. For details, will members please refer to item 1 of the agenda and also one paper which has just been tabled, CB bracket 4452 stroke 1819 bracket 02, list of outstanding items for discussion, and also at the next regular meeting to be held on the 25th of February 2019, we're going to discuss consultation paper on archives law and that on access to information regime, and 2, proposed creation of judicial posts and directorate posts in the judiciary, and 3, mainland judgments in matrimonial and family cases, reciprocal recognition and enforcement bill. These are items 1 to 3 on the list of outstanding items for discussion. Do members agree with the 3 items to be discussed at the next meeting? Yes, Mr. Dennis Kwok. Madam Chair, I agree that we should discuss these items at the next meeting, but I also would like to make a point. We have CB bracket 2 bracket 4433/1819 bracket 01 issued by the Department of Justice about the mutual recognition of judgments between Mainland and Hong Kong courts, and I understand that the public in general in Hong Kong are very concerned about this paper. I think it should be included in our list of outstanding items for the Secretary for Justice to come and discuss with us, and also to invite the 2 legal professional bodies to offer their comments. Well, actually, at every regular meeting, we welcome representatives from the 2 legal professional bodies. As for the Department of Justice, we sent the invitation, and they will send the representative of Department of Justice whom they deem fit, and definitely we're going to invite them to come. How about including this on the list of outstanding items? At the next regular meeting, this will be discussed. Is that right? I'm referring to the latest paper about civil and commercial law. All right, it will be put on the list of outstanding items. If there is no objection, next meeting we will discuss these 3 items. And we've also received a letter dated the 16th of January from Mr. Horace Cheung, Dr. Elizabeth Kwok, and Dr. Ann Chang about their request to discuss the pressure brought onto the judiciary by non-refoulement claims by the panel. Should we include this on the list as well? I see no objection, so this will be included on the list, and we'll find time to discuss it. All right, at the regular meeting of the 15th of February of the security panel, there will be a discussion on the topic of collaboration between Hong Kong and other jurisdictions on mutual legal assistance on criminal matters, and members of this panel have been invited to take part in that discussion. Previously, members already agreed to discuss item 15 on the list of outstanding items, MLA and arrangement on SFO between Hong Kong and Taiwan. Now, because this issue will be formally discussed by the panel on security at their regular meeting, I propose that this item be struck off the list of outstanding items. And I appeal to members that if you're interested, you can take part in the security panel's meeting. Last time when chair of the panel on security was discussing this issue, I also raised this point and suggested that we should discuss the matter and follow up in this manner. Well, next item is prosecution policy of the Department of Justice. Let me invite the administration to come in first.
呢份文件頭先問文件 table 咗未啊？喺邊度啊？等一陣嚇。咁咧就請官員進入會議廳。
Let's invite the administration to come in.
咁而家呢就係想大家參考。
I would invite members to refer to the following documents. Paper CB bracket 4452 slash 1819 bracket 03, CB bracket 4452 slash 1819 bracket 04, which are the administration's paper on prosecution policy of the Department of Justice and also the background brief prepared by the Electrical Secretariat on the same topic. There is also a submission from the Hong Kong Bar Association English version only. The paper number is CB bracket 4452 slash 1819 bracket 05. Mr. Dennis Kwok, Deputy Chair, and Mr. Alvin Yeung. Through this panel, also served the document to the Department of Justice seeking statistics from the department, and we've just received a reply from the DOJ which has been tabled for members' reference. Members who would like to speak, would you please now press the button to speak or raise your hand to indicate so. And please do it as quickly as possible because I need to draw a line in the interest of time. For members who are already here, if you are interested, please press the button or raise your hand. This is a regular meeting of the panel on administration of justice and legal services. I accord priority to members of this panel. Each member will be given 3 minutes. After members have asked questions, if time allows, we will, depending on the order of members, allow non-panel members to speak as well. So I will now invite the administration to brief us on this paper. Let me welcome the Secretary for Justice and Director of Public Prosecutions to our meeting. So over to you, Secretary. Thank you, Madam Chair. We have submitted the paper to the panel. I'd like to very briefly highlight some salient points in the paper. First, in relation to investigation and the work of the Department of Justice in Hong Kong, I'd like to make a start here. Investigation in Hong Kong is undertaken by law enforcement agencies, LEAs, and they do not directly come under the DOJ, but rather to the Chief Executive. The LEAs, after gathering evidence, the prosecutor of the Department of Justice will rely on the evidence so submitted to provide legal advice, including the decision whether the prosecution should be brought. After the LEA has submitted evidence to the DOJ, prosecutors of the DOJ will consider the evidence available and the prosecution code in deciding whether prosecution should be brought. And we need to consider a number of matters. First, about the independence of the prosecutorial decisions of the DOJ. And the Government Counsel and the DOJ are solicitors and barristers, and they also follow the same professional conduct applicable to the legal professions in Hong Kong. And they also act independently. And their independence is also protected under Article 63 of the Basic Law. DOJ of the Hong Kong SAR government shall control criminal prosecutions free from any interference so that prosecution can be taken out without fear of favor professionally. Article 63 provides constitutional safeguard. It provides that the DOJ of the Hong Kong SAR government shall control criminal prosecutions free from any interference. There have also been case laws suggesting that when Secretary for Justice fulfills his duty, she should be free from any influence. And we also need to consider the factors and the test applicable. According to paragraph 5.3 of the prosecution code, the prosecution must consider whether there is sufficient evidence to institute a prosecution, and the test is whether the evidence is sufficient to demonstrate a reasonable prospect of conviction. If there is sufficient evidence to initiate the prosecution will then consider whether it is in the public interest to do so. Now, on sufficiency of evidence, such that the test could be met, I'd like to elaborate on this point. The test is whether the totality of the admissible and reliable evidence, together with any reasonable inferences able to be drawn from it, demonstrates a reasonable prospect of conviction. The test is not whether there is a prima facie case or worse still, mere suspicion. For weak evidence or borderline cases, it is not in the interest of public justice or public purse that they should be prosecuted. About briefing out policy, the details are also set out in the paper. Criminal cases are usually briefed out in two categories. In general, before prosecution, external legal advice is needed, and also after prosecutorial decision has been made. And as usual, the prosecutor of the DOJ will make a decision whether to prosecute, and it is appropriate for outside legal advice to be sought if the proceedings involve members of the DOJ. Having considered a basket of factors, the DOJ will decide whether to seek outside legal advice. Even after outside legal advice has been obtained from a barrister or a solicitor outside, ultimately the DOJ is responsible for making a prosecutorial decision. Seeking outside legal advice before prosecutorial decision is made is not a norm of the DOJ. I note that last week Mr. Dennis Kwok moved a motion, and in this motion debate, some members referred to some previous cases alleging that it is the norm of the DOJ to seek external legal advice in sensitive cases or cases involving public figures, important persons, and I emphasize that for majority of cases, the DOJ made prosecutorial decision without seeking outside legal advice. Nature of the case and sensitivity of the case is not an hard indicator for the DOJ to seek outside legal advice. When a case involves a public figure, or when the case is sensitive, it is not mandatory for the DOJ to seek external legal advice. It depends on the circumstances. In the past, there have been cases involving these persons or sensitive cases, prosecution of which were initiated without seeking outside legal advice. We would not publish a statement for every such case, and as a result, these cases are not made public.
亦都寫得好清楚。
In the code, it is also made very clear that we will only use general principles and we will not disclose the details of each individual case, because giving a reason, it might contravene public interest or might not be appropriate. For example, given the legal privilege, I need to emphasize that in paragraph 23.34 of the code, it is stated very clear that when reasons are provided, it might be a bad influence, especially when a non-prosecution advice is given. It might lead to a public trial, and it does not safeguard our processes. So, as the Department of Justice, we need to make professional judgment. How much information can be included in the code, and we also need to provide safeguards. Thank you, Secretary of Justice. I had just received Mr. Dennis Kwok and Mr. Alvin Young, who seconded that motion. They have put forward a motion, and it is now being tabled. I'd also like to remind members, if you have any motions, you need to submit that as early as possible, and we will deal with them at the same time. So we'll now enter the discussion, and we have to thank the government for giving us an introduction to the paper. And now we will defer to Mr. Philip Dykes, and he will be speaking on behalf of the Bar Association.
Thank you, Madam. Francis Bacon was the Attorney General in the early 17th century in England and Wales. He described the post of Attorney General as being the painfulest task in the realm. Sir Patrick Hastings, the Attorney General in the first Labour government, under Ramsay MacDonald, described the post as like being in hell. The last Attorney General's decision in 1924 to discontinue a prosecution against a communist-backed newspaper after consulting political colleagues led to an opposition successful vote of no confidence in the administration, and the greatest defeat in the House of Commons history until earlier this month when Theresa May took that particular wooden spoon. The Bar submissions are designed to make the post of SJ a little less painful, and if not creating a heavenly dream for her, to make it a little less hellish. Things have changed a lot since the publication of the Shawcross Doctrine in 1951. This is paragraph 12 of our paper, which explained that the Attorney General's decision to prosecute were taken by an independent legal mind who might consult government colleagues but would never make decisions at their behest. The legal climate has changed in the 70 years since that was put forward. There's more awareness of the separation of powers, there's greater appreciation of the rule of law and what it requires, and the public have healthy mistrust what may appear to be self-serving statements made by ministers. Appearances matter, particularly in cases like this one, and that has given rise to today's meeting. And I read from the House of Commons report I provided you the words of Professor Zhao, a constitutional expert in England and Wales. He said, in 2008, one set of relationship in our democracy that has been subject to the most dramatic alteration in recent years is between politics and the law. The appropriate balance between those decisions, which are in the province of politicians, and those which belong to the law is one of the most fundamental questions in all constitutional theory and has great practical importance. The Bar assumes that the Secretary of Justice will not want to be involved in decisions to prosecute or discontinue prosecutions, save in the most exceptional cases. And in those rare cases where the Secretary of Justice's consent to prosecution is required as a matter of law, and that consent cannot be delegated under the Legal Officer's Ordinance. The Secretary of Justice would have better things to do. The Bar also assumes that it does not want a repetition of the criticism of the present case. So therefore, the Bar commends to the Secretary of Justice and to this committee the idea of a protocol as advanced in the annexure with our paper showing how the Attorney General in England and Wales, as a result of great consideration of how his role should be performed, has basically delegated all the prosecutorial order decisions to the Director of Public Prosecution and the heads of prosecuting departments, and retains only the right to intervene in very exceptional circumstances. That, in our submission, is the way that this panel should go forward. Thank you.
好，咁呢就係多。
Thank you, Chairman of the Bar Association, Mr. Philip John Dykes, SC. So if you wish to read the detailed recommendation, he does have a written submission. And our next speaker is from the Law Society, Mr. Stephen Hong. So my position is that a few weeks ago we had seen the Secretary of Justice providing 6 reasons when they decide whether they should brief out cases, and the current code, prosecution code, doesn't have these factors included. So I hope, first of all, for the sake of transparency, since the Secretary of Justice will be exercising discretion whether to brief out cases, including those 6 factors, then these factors should be included in the new version of the prosecution code. So that would be beneficial to the public. Thank you, Chairman. You still have time remaining. Anything you wish to add? If not, so I think we can set aside some time for your further responses. But now we have 17 members who have pressed the button to speak, and we will now set a time limit of 3 minutes for our panel members first before we allow non-panel members to speak. The first speaker is Mr. Hui Jifeng. Let's read out the list, the people in the queue, speakers in the queue. They are panel members first, Mr. Hui Jifeng, Lo Wei Kok, Alvin Yang, Chen Ginbo, Starry Lee, Chen Jichun, Jimmy Ng, Dennis Kwok, Eddie Chu, Martin Liao, Dr. Junius Ho, Fernando Zheng, and the non-panel members are Dr. Elizabeth Kwok, Lam Chung Tek, and Chong Tai. So, did Mr. Zheng Kwok-wan, did he raised his hand? So I think we'll add him to the list. So you raised your hand. So the secretary can take note of who raised their hand and who pressed the button. Mr. Zheng Kwok-wan had raised his hand very early, so we will place him earlier in the queue. So essentially, at this moment, we need to draw the line. Any other panel members who wish to speak, as I said, we will give panel members speaking priority. If that's the case, so Mr. Hui Jifeng, we've drawn the line. Thank you, Chairman. So, Secretary of Justice, in the UGL case, the DOJ decided not to prosecute and allowed a senior official, the ex-CE, to avoid a court case. There was no reason given. So a lot of the public suspicious. Is there any political consideration? Is there a political mission that you need to accomplish, or is there some collusion? So since you've stated in black and white some cases, if it gives people the doubt or suspicion that there's bias, then you should seek outside external legal advice. And on this case, you didn't do so. So I'd like you to explain why you didn't do that. And in the UGL case, the public feel that the DOJ, when you chose not to prosecute, was there any bias? Secretary of Justice? Thank you for the question. First of all, Chairman, I will not comment on any particular case. That is inappropriate. But when do we need external assistance? As I said just now, typically we rely on internal staff, and if it involves our staff, then we will seek external barristers' assistance. But in some certain circumstances, if there's a specific need, then based on that individual case, we will consider whether we need to brief out the case. And the paper has given 6 scenarios, and in each scenario we need to consider whether we need external assistance. So when we brief out, we are asking them to make a prosecution decision. I want to focus my question. I'd like to focus. I just want to ask, in the UGL case, you did not prosecute the ex-CE. Do you think the public feel that there is a bias, or your personal view? So, Secretary, you regarding Well, if you don't want to answer, then why, Mr. Hui Jifeng, you cannot. Today we're talking about prosecution policy. We are. So I will. When there is a Mr. Hui Jifeng, you need to answer legislators' questions. You are not here to repeat standard answers. Anything to add, the Secretary? I want to state that legislator said whether there was any perception of bias. Well, typically when it involves a person, in that case, the work can be conducted by DOJ staff until there is a conflict of interest. So you cannot just look at one issue. You have to look at each case and consider the evidence, the facts of the case, and so on. Mr. Lo Wai Gok. Thank you, Chairman. Chairman, the paper has said that in the last 3 years, the DOJ, DPP has provided more than 13,000 pieces of advice. So aside from DOJ cases, they need to seek outside assistance, and that is actually very rare. So put simply, in the last 3 years, there was only one case. So I have two questions. Since it refers to cases that don't involve the DOJ staff, so can you also tell us how many cases involve DOJ staff? And in the last 3 years, there was only one case, and I know the DOJ cannot give us details of the case, but could you explain this external assistance case? Why did you need external advice? And if you have time, well, the public, whether you prosecute or not, do you need external legal counsel? So some the outsourcing or briefing out of criminal cases, there is some misunderstanding. So I know that you also have a lot of regular work that needs to be outsourced. So could you explain that to the public? Thank you for the question. Let me respond to the last question and clarify our response. So when we seek external solicitors or barristers' assistance, there are two scenarios: before the prosecution, and one is after a prosecution decision is made. We need barristers to appear in court to represent the prosecution, to undertake court proceedings. Now, what we're talking about now is before, whether we had sought barristers' assistance before a prosecution decision was made. So legislator also asked, was that very frequent? So before a prosecution decision, it is not done frequently. As I said, it is not our typical procedure. So you also see that we provided figures from the last 3 years. So a legislator also asked for more information. It takes time, and we can provide that information because after we found the initial raw data, we had to clarify it, and we don't want to provide the wrong statistics. So in the last 3 years, you can see that there was only one case where we sought external legal advice. But I'm sorry, I cannot give you the reasons on this occasion.
As for legal advice involving persons or members of the DOJ, I do not have the figure at hand, but I don't think this is really the key focus at today's meeting. Mr. Alvin Young, Madam Chair, I'd like to ask Mr. Leung, Director of Public Prosecutions, who is familiar with the prosecution procedures. Now, for the former CE, Mr. Donald Tsang, was there outside legal advice sought before prosecutorial decision was made? Mr. Leung. Thank you, Mr. Young, for the question. In my recollection, if my memory serves me right, in relation to Donald Tsang's case, the Department of Justice issued a statement, and outside legal advice was sought. So, Madam Chair, for the Raphael Hui case, did the Department of Justice seek independent outside legal advice? Who is to take this question? The DPP? Madam Chair, at this moment I cannot recall because today's meeting is about prosecution policy of the Department of Justice. Well, never mind about that. I would not want to trouble the DPP. He can come back to that later if we still have time. Let's just focus on prosecution policy, all right? Madam Chair, I'm asking a question. Perhaps the Director, do you already have an answer? Because he is assisted by the colleague next to him. I want to confirm whether he has an answer now. I'm sorry, Mr. Yang, I do not have any accurate information at this moment. Timothy Tong case. DPP, can you confirm that outside legal advice had been sought? A question for whom? Director of Public Prosecutions. Yes. Madam Chair, I'd like to know. The Director has been serving the Prosecutions Division of the DOJ for so many years. Now, especially for Timothy Tong's case, there was a several-page statement stating the reasons not to initiate prosecution. Now, would you think that this would cause a great unfairness to Timothy Tong, such that it's a trial by public? Director, well, I don't think I should consider in my personal capacity or anyone's capacity whether the length of a statement would constitute trial by public for any person involved in the case. Well, Mr. Yang, you referred to Mr. Tong's case. It is not really what we should discuss about prosecution policy of the DOJ today. Let me further this question. Why would you need outside legal advice to decide whether to prosecute Donald Tsang and Raphael Hui? Has it to do with perception of bias? Anything to add, Director? Madam Chair? I think for every case, whether outside legal advice is needed would depend on the unique features of the case. There is not a one-size-fits-all rule. Next, Mr. Horace Chung. Just now, some members questioned the Secretary in relation to a particular case, and then members questioned the prosecutorial decision of that case, and then the Secretary was accused of colluding with the accused and letting off this person. Well, this member is obviously very unhappy with the prosecutorial decision, and today he is trying to find a gray area in your prosecution policy to question your prosecutorial decision of not to prosecute that person. Now, whenever a prosecutorial decision is made, I wonder if we should incessantly question the DOJ's decision both before, during, or after this meeting. Just now, Mr. Alvin Yeung, another member, referred to some previous cases and asked a member of the DOJ. He referred to the cases involving Donald Tsang, Raphael Hui, Timothy Tong. Now, I'd like to take the same approach as well. Let me ask the Director of Public Prosecutions. What about cases involving electrical members receiving donations from Jimmy Lai, Lee Cheuk-yan, Tanya Chan, Claudia Mo, so on and so forth? Back then, you made the prosecutorial decision not to prosecute them. I want to know whether at the time you sought outside legal advice as well. Secretary or DPP? Madam Chair, yes, Secretary. Let me respond by saying that in relation to every case, whether an external counsel's advice has been sought, it is not really a helpful indicator because we have different features of the case, and each officer handling the case may have their own professional judgment. Now, just now, the honourable member referred to some cases. They were reported in the newspapers, and Mr. Horace Cheung also referred to a case. If my memory serves me right, and I don't want to give an inaccurate answer, I do recall that we haven't sought external legal advice in this case. Now, I still have a little time left. I want to say that this is not the norm, that outside legal advice must be sought. Now, perhaps like the representative of the Law Society said that, in fact, this is not the norm. As member of the AJLS panel, I remember, according to minutes of the meeting held on the 26th of February last year, paragraphs 13, 14 made it clear, because some members asked about the following. That Mr. Horace Cheung just referred to. According to the DOJ's written reply, no outside legal advice was sought. So maybe you can refer to the minutes of the meeting dated the 26th of February last year. According to the DOJ's written reply, paragraph 4, the answer is clear. Next, Mr. Chan Kin Po. Thank you, Madam Chair. Earlier, about the Jimmy Lai donation incident, the DOJ was criticized for not seeking outside legal advice. For the CY Leung case this time, again, the DOJ has been criticized the same. So for controversial cases attracting public attention, the DOJ should standardize approach and seek outside legal advice to avoid being criticized about this prosecutorial decision. Well, the DOJ may be criticized as not taking responsibility, but on the other hand, you can prevent the accusation of being biased. I don't know why you don't want to take the easy way out. And also, according to an interview conducted with a former DPP, well, seeking outside legal advice is not the international norm. It's a waste of money and time, and the Hong Kong government should review this practice that could be dated back to the colonial era, because money could be spent on hiring more prosecutors to expand your establishment. This is a valid argument because this will provide practical opportunities for government counsel to have experience. So my question for the Secretary is whether you will consider this suggestion carefully. Secretary. Thank you, member, for the question. Article 63 of the Basic Law provides that the DOJ should control or shall control criminal prosecutions free from any interference. And this is done on two levels. First, constitutionally, our independence is safeguarded. At another level, we are also given the constitutional duty to make decisions. If members of the DOJ could make a prosecutorial decision, it is the DOJ's duty to do so. If there are legal issues that cannot be resolved within the department, the officer concerned should exercise professional judgment and discretion to seek assistance from external counsel for legal advice in order to reach a prosecutorial decision. In other words, for members of the DOJ who, through deliberations and discussions, could handle this decision-making process, there is no need to seek external legal advice because DOJ is given the constitutional safeguard in Article 63 of the Basic Law. Second question relates to the briefing out policy. We have heard different views, including Mr. Kwok Man Wai. His views was published in the newspaper. I understand that some legislators also hold opposing views on outsourcing. And we have been reviewing the briefing out policy to see if change is needed. as far as our policy is concerned, when we should brief out an external counsel for court proceedings, we do have considerations. Next, Ms. Dari Lee. Madam Chair. Well, many people think that we support you, Secretary for Justice, but in fact the DAB supports the basic law and the safeguards it provides. Now, because for the corruption agency in UK, there is insufficient evidence to initiate prosecution in UGL case. Now, we do have very strong views on your work, Secretary. For Occupy movement, we have waited for 3 years before you finally decided to prosecute the accused. Well, in fact, the organizers, there were some 40 of them, but only 9 were prosecuted. On the contrary, some young participants were convicted and sent to prison. Even police officers. We are very unhappy with your work. And apart from delay in prosecution, we also question the problematic political donations. We also question whether you sought external legal advice on the case involving legislators Claudia Mo, Lee Cheuk-yan, etc. Well, can you answer directly? It's not just criticisms coming from us, and in fact, we have this headline in the news. You are criticized by another department. So, Secretary, you're facing a lot of criticisms. I hope that you will give us a very serious answer and help us vent our spike. Well, according to the basic law, we need to respect how you conduct your work. Now, would you please respond to my questions? Secretary, your response? Thank you, member, for the questions and the comment. It is absolutely correct that we need to support this system. We need to support the constitutional and the legal system. And this is a comment coming from the member. Well, what about the Occupy movement case? You did not prosecute until 3 years later. And did you seek external legal advice about political donations? We have waited for your answer for so long. But please give me some time. It is very important to support the system. I hope everyone will be clear. It is not just about an individual. It is about the whole institution. As for Occupy movement, prosecution hasn't been initiated until recently because of the court arrangements. It is arbitrary to say that which single party should be responsible. Anyway, I should not comment on it. Proceedings have commenced. And about the political donation case, yes, please wait. You need to wait for the Secretary to finish the answer. I have a point of order, Madam Chair. I want her to clarify what is meant by black political donations, because she kept referred to this in Chinese, black political donations. What do you mean? Is it about money laundering or what? Mr. Ray Chan, I have a similar point. All right, please clarify what you mean. Black money, literally in Chinese, can you explain what it is? But I've already reminded everyone that is recorded in the minutes of meeting. Please go back and retrieve the minutes. Please refrain from shouting from your seat. We have so many members wanting to ask questions and many people watching the webcast. Over to you, Secretary.
The other case I was referred to just now, I had responded. Please stop for a while, Secretary. I said I allow non-panel members to attend, but non-panel members, please do not shout from your seat because we don't have time for non-panel members to speak. Mr. Lam Cheuk-ting, I have asked the Secretary to respond to your question. You have to allow the Secretary to respond. You want her to respond. Do you have anything to add? We won't comment on individual cases. You have to understand we cannot comment on individual cases. So wherever we are talking about prosecution policy today, and I hope that DOJ can refer to the minutes of February 2018. You can respond, you can refer to your written response. 26th of February 2018, Mr. Eddie Chu mysteriously described political donations, and I'm not sure the secretary made a mistake or was just repeating. And your description has given rise to confusion. So I want you to clarify what you said in Chinese when you said black gold. You cannot avoid the issue. Now I need to chair the meeting. It's already 5:16, and we have 16 members who want to ask questions. Secretary, do you want to respond further on the definition of political donations? No comment. So Secretary is... Well, you can clarify yourselves. Next, we have Mr. Tan Jichun. We have limited time. If you want to ask questions, then you have to cooperate. Mr. Tan Jichun. Chairman, I'm using my time and I'm asking the Secretary to answer. When Starley, she was describing political donations and she was using the Chinese term black gold, so you've fallen into the trap. You have to explain to the media why people weren't prosecuted. Now, last week, the Secretary was referring to Article 63 of the Basic Law, and Article 63 is that criminal prosecution should not be interfered with. It seems like we are interfering today, so you shouldn't attend this meeting. You shouldn't be speaking on prosecution policy. We have a lot of criticism. We will give you a lot of examples. The second excuse is paragraph 21. It's the only part that is underlined. So, however, the benefit of justice being seen to be done must not be allowed to result in justice not being done. So, whether you seek external help and whether you disclose reasons. But I need to speak a little bit about seeking independent external assistance. You need to clarify. When you outsource it, it is not shirking responsibility, because ultimately you have to make a decision. It doesn't mean that you don't have work to do when you outsource the work. Well, why do you outsource the work? Well, it's to avoid suspicion. Do you know Mr. C.Y. Leung? It's not the... Do you have business dealings and private dealings? If there was a case where the judge said, I recall that I joined a trip with Mr. Albert Chan, so to avoid suspicion, I would not sit on that case. So coming back to this publication of reasons, you say that it will affect public interest. But when you don't disclose, will it also affect public interest? You know, our previous Director of Public Prosecutions, he said that when there's insufficient experience, he was just being modest. He was actually saying that you might have been wrong. Any response, Secretary? Well, I don't want to respond on opinions, but regarding publication of reasons in the Hong Kong rule of law, there is a very important cornerstone that is innocent until proven guilty. So if we cherish this value, then we cannot assume people are guilty because of media accusations, and we need to restore their state of innocence. So I want to refer to paragraph 29D, where we have conflict of interest. And when you deal with a case, let's say it's a senior government official, they are being investigated for a murder case. Let's say the incident occurred on 1st of January, but then you subsequently realize that the person was not in Hong Kong on the 1st of January. But since the person is a political figure or a senior official, will you So when you don't have evidence and you want to give people the impression that you're not being biased, will you still seek outside external assistance? Well, in your example just now, I think the few points we covered, we don't need external legal assistance because, of course, we need to consider the proof, the validity of whether the person wasn't in Hong Kong and whether that proof can be established in court. And assuming if it's acceptable and the person was not in Hong Kong, and when we consider the legal rules and we look at the prosecution code, when we can make a decision, then we won't seek an independent external help just because the person is a senior official. That is not our procedure. Okay. Mr. Kwok, Dennis Kwok. I have no intention of discussing individual cases. I want to say that in the paper, it refers to the DPP having an important role. So I want to ask the Secretary, the DPP sitting next to you, he was appointed in 2007, but why on January 2019, when we have legislators questioning why do we have to wait more than 12 months before we get the approval? What is the reason behind that? Why previously the DPP, Keith Young, he could be appointed in 1 month, but Mr. David Leung, SC, sitting next to you, has worked in the government for more than 25 years. Why did his application take so long before he was appointed? I would like to ask you why. Chairman, this question and related questions, as far as I know, Mr. Dennis Kwok had raised a written question and our colleagues have dug out the relevant information. I'm asking you, Secretary, Mr. Dennis Kwok, as Secretary, what decision did you make? Why was Mr. David Leung, SC, approved? Why did it take so long? Well, Mr. Dennis Kwok, you want to use your 3 minutes to ask something that is not directly related. It doesn't matter. The paper has talked about DPP on numerous occasions. You cannot say that is irrelevant. We're talking about prosecution policy. We have to talk about DPP. Well, if you want to, if the DPP sitting next to you, why did it take more than 12 months before the CE could approve his appointment? Well, first of all, I'm chairing the meeting. I'd like Deputy Chairman to not speculate on people's motives. Well, you have to chair it fairly and squarely. Well, how is it not related to prosecution policy? I'm asking you. Even though I don't expect the Secretary to answer this, but you cannot stop me from asking the question. Why is it not related to prosecution policy? I want to rule it as not related. So, Secretary, do you wish to use your time to respond? Chairman, I said that regarding Mr. Dennis Kwok's written question, we will respond. So, moving on, Mr. Eddie Chu. Mr. Eddie Chu, could you restart the clock? Thank you. Now, Article 63 of the Basic Law, a lot of our colleagues have been quoting it, the government has been quoting it, the SAR, the DPP worker should not be interfered with. So I think having this in the BL, it wants the public to believe that the DOJ will only look at the laws, it will not look at political factors. But now, can the basic law guarantee this? Because the CE will nominate the Secretary of Justice, and the central government will appoint this person. So it's a politically appointed role, so it involves politics. So my question is, if the central leadership, they are involved in Hong Kong criminal investigations, then an official appointed by the Chinese central government, it seems that in the past you have not dealt with this issue. So whether there should be outside independent legal advice, or how do you avoid conflict of interest? There's a vacuum. Just now, the Bar Association recommendation, would it be something that you would adopt if you were to deal with central government officials involved in criminal investigations? Would you seek independent outside legal advice? Thank you, Mr. Chu, for your question. When we do prosecution work, the whole DOJ, myself and my colleagues included, they are autonomous, independent. It won't be because of a person's political background or social standing leading to any bias. For example, in paragraph 1.2 of our prosecution code, we will not give any preferential treatment to a person or political group, or we won't consider public response or media influence. Well, you are just reciting from the code. Now, if you yourself are an official appointed by the central government and you are not involved in a criminal case that involves central government official, how can you instill confidence in the public that you are independent? Well, in our prosecution policy, it is stated very clearly. All our staff are either solicitors or barristers, and we can live up to our standards. So you referred to the suggestion made by the Bar Association. The DOJ cannot consider that because it involves a whole constitutional arrangement. Mr. Martin Liao. Chairman, this is the fourth occasion in LegCo where I have heard the Secretary of Justice respond to public prosecution issues. I'll also note that the Secretary of Justice has stated repeatedly that the DOJ outside independent policy has not changed. But earlier, the SJ conveyed to the media that there were certain exceptions. So could the Secretary clarify for us? Secretary?
議員嘅
Thank you, Mr. Liao, for your question. Before making a prosecutorial decision, if outside legal advice is to be sought, this is not the norm of the DOJ. Usually, prosecutorial decision will be made within the DOJ. But if the case involves members of the DOJ, it is appropriate to seek outside counsel for legal advice. And if there are special circumstances in relation to the facts of the case or the legal points in the case that warrants outside legal advice, the DOJ may consider seeking outside legal advice for that case. The paper already sets out 6 scenarios that forms the general rule of the DOJ. Next, Mr. Junit Ho. Secretary, it's been really hard for you. You're sitting on the edge of your seat. Well, my fellow members keep asking you whether you have sought outside legal advice or senior counsel's advice for this particular case. In fact, I have another case that is very obvious. That is Jimmy Lai threatening a reporter of the Oriental Daily. Now, you decided not to initiate prosecution. Did you explain your reasons? Did you seek outside legal advice? I really have so much respect. I have this question in mind. I really want an answer. But then I also respect Article 63 of the Basic Law, which provides that the DOJ of the Hong Kong SAR government shall control criminal prosecutions. And for the prosecution policy, it was formulated in 2013. This prosecution code spans 56 pages. And now it is becoming problematic. According to some members of this council and legal professional bodies outside, they question why you are not following this prosecution code. On the other hand, I understand there is respect for, say, Article 86 of the Basic Law, 25, 35, these articles in the Basic Law, and the prosecution code refers to these articles. Now, you refer to Article 63 of the Basic Law as your trump card today, but it seems that the prosecution code does not contain anything about Article 63. You talked about transparency, but it is so transparent that we know you are ignoring this constitutional safeguard enshrined in Article 63 of the Basic Law. It is not in the prosecution code. The prosecution code was drawn up in 2013 because of the controversies sparked in the community. Would you make it clear that the prosecution code is not really binding on your prosecution work because you make the code? Or would you say that you are bound by Article 63 of the Basic Law? Does it have any overriding effect or not? Please explain clearly to us. Or can you tell us that Article 63 is a very important provision, and prosecution work is bound by Article 63 and you have the ultimate control? So would you consider revising the prosecution code so as to spare any future discussion of these matters? Secretary. Thank you, Madam Chair, and thank you, Member, for your comment. In fact, please allow me to answer very briefly. In our prosecution code, in terms of the independence of our prosecutors, paragraph 1.3 sets out very clearly that Article 63 of the Basic Law of the Hong Kong SAR provides that the DOJ shall control criminal prosecutions free from any interference. That constitutional guarantee of independence ensures that prosecutors so and so. I'm going to amend this constitutional guarantee, this word, because it is not constitution. And I go on, ensures that prosecutions within the department may act independently without political or other improper or undue influence. And the next paragraph refers to Secretary for Justice, and the case is quoted about the prosecutorial independence of the Secretary for Justice, Dr. Fernando Cheung. Thank you, Madam Chair. I'd like to put a question to Chairman of the Bar Association about Article 63 of the Basic Law. The DOJ of the Hong Kong SAR government shall control criminal prosecutions free from any interference. Does it mean that for a relatively sensitive and controversial case in which the DOJ could possibly make a decision not to prosecute, and that which may constitute a possible perception of bias or possible conflict of interest, and in such a case, if the DOJ refuses to explain in detail the grounds, it is still all right, and that is about Article 63 of the Basic Law. And the DOJ on this occasion has decided not to prosecute CY Leung for accepting a $50 million payment in a UGL case. Mr. Philip Dykes.
There is nothing in the Basic Law which requires a public prosecutor to act in a situation where there is a conflict of interest. The common law would intervene and will vitiate a decision that's made in those circumstances. So I would say that briefing out, or, as we recommended, establishing a protocol whereby 99.9% of the prosecutorial decisions don't cross the desk of the Secretary of Justice, is completely compatible with the basic law. If a decision to prosecute is made in circumstances where people may say there is possible bias there, you've been influenced by third parties, then there are political consequences, and I refer to an English case in 1924 where the Labour government fell as a consequence of the Attorney General getting it wrong in a particular case, or there are legal consequences. In 2008, the House of Lords had to deal with the decision of a judicial review of a decision to prosecute in a bribery case concerning officials from Saudi Arabia, where it felt that the decision to discontinue the prosecution had been vitiated by the prosecutor, the Attorney General, and the Director of the Serious Fraud Office being affected by commercial considerations and the consequences of a decision on the commercial relationship between Saudi Arabia and the United Kingdom. So that's a possibility.
OK，謝偉俊。
Mr. Paul Chair. Madam Chair, responding to Mr. Dyke's remarks, of course, under some circumstances, the Department of Justice may be questioned for being biased. But according to paragraph 25 of the Bar Association submission, if we are to refer to the UK practice to form a protocol following the 2008 report, and that all cases, unless under special circumstances, should refer to the DPP for prosecutorial decision, except in the case of national security issues, or that the case involves a political party or members of the parliament. I think that if this practice is adopted, it will contravene Article 63 of the Basic Law. In UK, this is easier because they do not have a constitution. For example, for the prisoner's right to vote, obviously it contravenes the European Union's Human Rights Convention, but they are free from any constitutional straitjacket. So perhaps this is my comment. Perhaps this is not suitable for Hong Kong. On the face of it, your proposal is fair, but Hong Kong's situation is unique. Coming back to prosecution policy, past president of the Law Society of Hong Kong, Mr. Stephen Hong, referred to the 6 points in paragraph 29 of the paper from A to F. Now, for the time being, these are genuine reasons, and it is true that these 6 points are not explicitly provided in the prosecution code. So, Secretary, would you consider in your briefing out policy including these 6 points in your prosecution code? Question number 3, under what circumstances would the prosecutorial decision be passed from the DOJ to the DPP? Because we have precedents in previous cases, and again, in your policy, it doesn't clearly define the circumstances. Although we have Article 63, we have questions and issues, and like Mr. Dyke said, I'd like to know the circumstances in which prosecutorial decision will be made by the DPP. Another point, we need to be fair to the persons concerned. Perhaps we should publish more facts. I am against that. When it comes to, say, veto procedure in this council and other matters, some members would always say, let's go ahead anyway. But this is just an excuse. Well, I've run out of my time. Next, Mr. Felix Chung. You're the last non-member to speak, all right? Please allow me to deal with this first. Just check the screen, Mr. Felix Chung. Thank you, Madam Chair. I think for the general public, They would think that if you put a question to a lawyer, if you put 10 questions to a lawyer, you would get 11 answers. So my question for the Secretary is about your briefing out policy. What are your considerations for briefing, say, this chamber and not that chamber? When you engage a counsel, a barrister, perhaps this barrister already has a preconceived stance on this particular matter. So about your prosecution policy, I'd like to know your consideration in engaging an outside counsel. Secretary, this is a very good question. Of course, there are different opinions from different lawyers. Of course, there may be 11 different opinions from 10 lawyers, so on and so forth. So in deciding whether we should seek outside legal advice, the most important consideration is whether there is capacity within the department to make this prosecutorial decision. And if there is capacity for the DOJ to make this decision, there is no need to seek outside legal advice. Now, for some individual cases, for example, when the relevant provisions in the laws are not ready, are not fully mature, and it may be wiser to seek legal advice. And under such a circumstance, we may consider seeking legal advice. And of course, the officer in charge would also have his own professional judgment. We need to respect that. Now, we have some cases in which the facts are quite special, and there is no precedence, and for clarity's sake, legal advice would also be sought. It is also very important who we should engage, because we would want to avoid the perception that we are transferring benefits and that we often engage just a handful of barristers or senior counsel. So when we seek outside legal advice from a senior counsel or barrister, we have an established policy to ensure fairness. Well, in deciding who should be engaged, we need to consider the professional discipline of the barrister, whether he has expertise in this area. This is our consideration, Mr. Felix Chung. But within the DOJ, you do have a list. There is already a list for you to consider who will be your top choices. I won't say there is a list of top choices, but we understand which barristers are familiar with criminal cases or their relevant areas of expertise. We do have this information. Next, Mr. James Toh. Madam Chair, I have a question for the administration. Paragraph 29, D. It is deemed appropriate to obtain independent outside counsel's advice or services so as to address possible perception of bias or issues of conflicts of interest. Now, I have a simple question for the Secretary. Possible perception of bias. Whose perception? Are you referring to the community or the Secretary's own perception of bias? Secretary. Thank you, Mr. Toh, for your question. About the wording, possible perception of bias, this can be construed as to mean apparent bias.
So why do we use the concept of apparent bias? Because the perception we're talking about, if you apply a legal test, it's an apparent bias. As Chairman, my question was, this person, is it other person, members of the public? I still have 2 or 3 questions. I'm just asking simple questions. Let's allow the Secretary to answer. I'm not avoiding your question. I need to explain. Giving a person a perception, it's an objective, informed, and a fair-minded person. So that is an objective, fair-minded, informed person. So if a decision, you feel that a fair-minded member of the public a very reasonable person. This person would feel that there's no bias, so you decided to not seek outside independent counsel. But then the majority of society would feel that decision is incorrect. Or they might even feel that there's a chance of bias. So here arises my difficulty. There are some cases of this nature. There are two possible scenarios. One, you will say, these Hong Kong people are not fair-minded persons. They're not normal. The other possibility would be, then you have to step down, because if the majority of the public feels that there's a bias in this case, but you feel that there's no bias, and we might be facing this situation. Secretary, are you aware that we're facing this difficulty now? Let me try to answer Mr. To's question. The legal test I was referring to just now, typically, you can answer. Typically, this is a quasi-judicial test or judicial test. So if some people feel that it is applied wrong and other circumstances in the courts, you could raise an opinion. You could ask for a judicial review, or you could challenge the arbitrator or a judge. There is a procedure where you can take that up. Next, Mr. Lam Chok Teng. Chairman, previously the Secretary of Justice made a statement and said that in recent years there have been cases involving senior officials, and the DOJ made the prosecution decision and did not seek outside independent legal advice. So I want to ask, can Secretary provide some statistics? I think you have done the statistics in order to make that statement. So in recent years, how many cases involved ex or current senior officials where you did not seek outside independent legal advice and you made the decision yourself? Do you have these statistics, Secretary? Chairman, I don't have the figures right now, but I would like to take the opportunity to repeat. This kind of information is not appropriate to disclose. Can I answer? Thank you. Please allow me to respond. If the person has undergone an investigation and it's brought to the DOJ's attention, and if there is no insufficient grounds for conviction, then this person, we have to assume they're innocent until proven guilty. I'm just asking for statistics. What are you referring to? Innocent before proven guilty? I'm just asking for statistics. I didn't mention any names. Did you listen carefully to the question? So, under these circumstances, we have not made records of the individual cases. Well, you made a statement. You said that there was a case where you did not seek outside independent legal advice and the DOJ made the decision itself. Well, since you make that statement, you must have done some work. You've done some statistics. So you don't have the information right now. Could you disclose that information? After the handover, how many cases involved senior officials and you did not seek outside independent legal advice? Please list it out. For example, if they are central government appointed officials, I don't want you to change the goalpost. So central government appointed officials, I just want the figures. I'm not asking for names. Could you give us the statistics? Chairman, as I said, our prosecution work, our internal work has to be confidential. If you take people, certain type of people, and disclose the information, so you won't give us statistics? Well, then you said there are so many cases where you did not seek outside help. You won't talk about cases. You won't talk about statistics. Well, then that's just an empty statement. So you can go back and consider what kind of information can be disclosed. You can provide us with that information. Dr. Elizabeth Kwat. Well, I believe the whole Hong Kong public will agree that rule of law is very important to Hong Kong. So everybody would expect that if everybody sees that there's sufficient evidence that the guilty should be dealt with by our system, but then there are some members of our society, so whatever they have done, whatever laws they've broken, they seem to be protected. If they are media moguls such as Mr. Lai Jiying, so they are not arrested, they are not prosecuted. And just now our legislators mentioned that they allegedly threatened Oriental Daily reporters. There are pictures, but after 19 months there's no prosecution. And just now Ms. Starry Lee said that she talked about political donations. Some legislators received 43 million, and political parties also received donations, and they are not prosecuted. They are scot-free. So forget about Occupy Central. I ask this question every time in LegCo. You see, Lai Jiying was one of the instigators of Occupy Central. So these cases have been affecting Hong Kong for the last few years. So when media moguls, they can say anything they want, they can threaten reporters. There's no regard for freedom of press. Secretary, we deal with evidence. We apply the prosecution code. So whether that person is a media mogul, so whatever social background they have, it is not relevant. We operate without fear. We deal with everybody the same. So some decisions, when they are made, some people will be happy, some people will be unhappy, but that does not affect our work, which is done in a fair, just manner. We have to operate under Article 63 of the Basic Law. We cannot bow before pressure. We should not prosecute when we shouldn't, and we shouldn't. This will not occur in the DOJ. But that's what the Secretary says. But when we don't see how it is operating without fear or prejudice. Now, I want to ask, if somebody waves their finger at you and verbally assaults you and says, "I've taken pictures," do you think that it would be criminal intimidation? Well, I don't think I cannot give you a simple, direct answer here. Let me say it once again. When we consider evidence, as our prosecution code says, we have to consider this, whether the evidence can lead to a conviction, what defense there is, and after examining all the evidence, can we have a successful conviction? Next, Mr. Zheng Chongtai. I totally agree that the DOJ is unfair. I think I'm a reasonable person. We have people taking selfies and they are not prosecuted. So the Secretary said that some people are involved in political donations and they are not prosecuted. Well, we should prosecute all these people. So I want to ask a serious question. That was a serious comment as well. I want to refer to the prosecution code, paragraph 7.4. It refers to the DOJ regarding the DOJ can intervene regarding private prosecution, and there are some criteria. It has to look at the severity of the crime, the conflict of interest, whether it's a repeat case, whether there can be a fair trial. So the DOJ can intervene based on these considerations, I want to ask the DOJ whether they have sought outside independent legal advice or not. They are not going to prosecute. So some members of the public or legislative, they want to call for private prosecution. Then regarding these cases, what kind of standards will the DOJ apply on whether they will take up the case? Thank you for the question. The factors we need to consider in paragraph 7.4, they've been listed, so it is hard to give you some sort of hypothetical outcome. We do have some case examples for reference and how we should make the decision. But the factors are listed, I understand. But the DOJ, let's say, regarding UGL, said they won't prosecute CY Leung. But somebody wants to make a private prosecution. So the DOJ can apply 7.4E, saying that it is consistency with decision of the Department of Justice and not allow that private prosecution. Well, I'm not a lawyer, but that's what it seems to read. Well, we consider all the relevant factors, and overall speaking, if we need to consider 7.4 and the relevant factors, after we take over the case, how we approach it will depend on the circumstances before we make a decision. So we have received an extra motion from Ms. Starry Lee and Mr. Martin Liao. We now have 2 motions. So after I speak, we will deal with the motions. We cannot give you any extra time for questions. So I want to say, first of all, whether DOJ panel members, non-panel members, you need to refer to minutes of 26th of February 2018. I would like DOJ staff to be better prepared for the meeting. In paragraphs 13, 14, it states very clearly, especially Mr. Cheung Kok Kwan and Ms. Starry Lee's question, you had already provided a written response. You said that you did not seek outside independent advice. So you need to read up your past records, and your colleagues should dig up these records. Second, regarding outside independent advice, you gave us a very detailed document. There were 6 conditions where you would seek outside independent advice. So I would like you to be familiar with that document. It's very clear because we have discussed prosecution policy on numerous occasions. So it involves financial resources and also efficacy. We had asked, there are so many cases that need outside independent advice. How do you decide? I had helped out with many cases, just people seeking help. So I'd like you to respond. The barrister, of course, wants to take it to court, and some witnesses might have even deceased in the meantime. And if you insist, if the barristers insist, they'll have to take it to the courts.
And basically, you dare not make any comment after the case has been briefed out. For the counsel on Fiat, of course, he would like to go on. Well, have you had this experience that in the middle of the trial, you think that there is insufficient evidence and that the counsel in the DOJ has another opinion? But in fact, we have seen this recent case. You even lost the case. It's a really major indicator. Have you taken this responsibility that in the middle of the proceedings you would think that it's not quite all right. And the other point is about Article 63 of the Basic Law. It is the DOJ's responsibility to have prosecutorial independence. You cannot delegate this decision. You are accountable to the public. You are the one making prosecutorial decisions. Now, you cannot make and point number 3 for Council on Fiat, how do you guarantee that they are politically neutral? Because when you seek external legal advice on a particular prosecutorial decision, maybe things get quite political. Of course, in the minds of lawyers, they would like to go ahead. Now, it's a very simple point, but I'd like to have a response from you. Anything to add, SJ or DPP? I thank Madam Chair for your comments, and I agree very strongly in relation to Articles 53 and whether prosecution divisions can be independent, can survive as an independent unit. As for the previous statements we made that we are not clear, of course, I'll follow up on the matter. Third point, the outside counsel may give an advice to go ahead, and then midway, and when we find that it doesn't work, we may stop it or we may find an alternative. I must not comment on previous cases. You may recall in 2018 there was 0 case involving outside legal advice. So during my office, I have not come across this situation. However, after seeking outside legal advice, we would consider the legal advice, and if we believe it is not good, we will not use it. That is why I say if we are capable of dealing with it within the DOJ, we will do it ourselves. We have received 2 motions. I believe they have been tabled. Please read them very carefully. The first motion is moved by Mr. Dennis Kwok, seconded by Mr. Alvin Yeung. I believe this motion can be dealt with by this panel. Mr. Dennis Kwok, would you like to read it out? It will also be projected on the screen, and then we'll go ahead and proceed with this motion. Please press the button to vote. This panel has no vote of confidence in Teresa Chang, Secretary for Justice. All right, you want to claim a division? The bell will ring for 5 minutes.
讀咗啦，係嘛？
即 grade 訂2個，冇意思。
陣間都係用個按鈕。
Please press the button to vote. Only members can vote. Please bear this in mind. Only members can vote.
趁而家呢個時間提一提下，請
Well, let's make use of this time to remind members that please take a seat according to the seating plan of this conference room.
Hảo, 請大家進行
Please proceed to vote. Have all members voted? Please check your votes. Voting is closed. The result is displayed. 11 against, 7 for, abstention 0. The motion is not carried. The second motion, Ms. Starry Lee and Mr. Martindale, please quickly read it once. The rule of law is a cornerstone of Hong Kong's success. It is also a very important core value in Hong Kong. Article 63 of the Basic Law provides that the DOJ controls criminal prosecutions free from any interference. It safeguards the rule of law in Hong Kong and ensures that the prosecution of the DOJ acts independently without any undue influence or political pressure. It is very important. This panel urges all sectors of the community to follow the stipulations in Article 63 of the Basic Law to avoid any improper pressure put on the DOJ in drawing up the prosecution code and deciding how to make the prosecutorial decisions so as to undermine the power and obligations of the DOJ in exercising independent prosecution decisions. And also the panel urges the DOJ to continue to act independently and professionally according to the prosecution code. There is quorum here where we don't need to ring the quorum bell. Now, Dr. Lo Wai Kwok has claimed a division. Would members please make sure that you are in the seat assigned, and we now proceed to vote. If all members voted, please check your votes, members. Voting is closed. Please display the result. 18 present, 11 for, 7 against, no abstention. The motion is carried. We are behind schedule and we need to move on to the next item. I'd like to thank the Secretary for Justice, Chairman of the Bar Association, past President of Law Society of Hong Kong, and all of you attending this meeting. We now move on to the next item. Next item, review of duty lawyer fees. I will invite the administration to come in. Would members please note CB bracket 4452/1819 bracket 06 and CB bracket 4452/1819 bracket 07, which are respectively the administration's paper and the electrical's background brief. If members wish to speak, please either press the button or put your hand up. Yes, may I invite the administration and the Bar Association representatives to take a seat. I will now invite the administration to walk us through the paper. Yes, Mr. Choi, Director. Thank you, Madam Chair. In the interest of time, I'll try to be as succinct as possible. The recommendation of this paper is set out in paragraph 9, and that is we propose to substantially increase duty lawyer fees by 56.2% for whole day fee, half day fee, and pre-trial preparation fee. In the future, the rates will be adjusted in accordance with paragraph 9. Now, the background is that, as we all know, last fee review of the duty lawyer service was conducted in 1992. There was a one-off adjustment of 27%. Since then, the rates have been revised on the basis of inflation movements, and in recent years, having heard views from the community and members, we believe that we need to implement a substantial adjustment so that the DLS fees will be on a par with the LAD fees, since we are sharing the same pool of lawyers, so that there will not be undue or unfair advantage in competing with the same pool of lawyers. As statistics show, over 60% of duty lawyers engaged under the DLS, and close to 90% of lawyers in private practice taking up criminal legal aid cases for LAD in the past 3 years were lawyers with 10 years or above post-qualification experience. So the DLS and the LAD are competing for the same pool of experienced qualified lawyers, and having regard to the close resemblance of the nature of work undertaken by duty lawyers and counsel, we propose to adjust the duty lawyer fees upwards by the same percentage.
So if you look at the criminal cases in legal aid department, and aside from the inflation figures every 2 years, our recommendation is a 56.2% increase. So we have put forward this recommendation. The government is not doing this in a vacuum. At the time, when the Home Affairs Bureau was still in charge of the policy, we had set up a working group, and it involved representatives from the bar, from the law society, from the DOJ, and in fact, my colleague sitting next to me was a member of that working group. So when we review future rates, in the paper we recommend that when we revise a criminal legal aid, we will also revise these rates. At the same time, we want to maintain parity with the legal aid department and the DLS. So if it is approved, then on 1st of April, we will increase the rates such that all the duty lawyer scheme lawyers can enjoy the increase. Thank you, Ms. Choi. We now invite representative from the Bar Association, Mr. Philip Dykes.
On this matter.
Yeah.
Chairman, I will be dealing with this issue. So aside from representing the Bar Association, I personally, from January last year, I was also a member of the working group. So I will be wearing two hats, and I want to express the view that we welcome this adjustment, and from our perspective, that should have been done a long time ago. And you see the paper refers to the last revision in 1992. So regarding the rate of increase, if you look at the duty lawyer scheme, and if you compare that to the legal aid department and the outsourcing or briefing out fees, then it is fair to all the lawyers dealing with criminal matters, and it is sufficiently attractive. So even though the government has said that they will take the DLS and legal aid department fee and the DOJ outsourcing fee, they will review these at the same time. That is very fair, and we welcome that. But in the paper, we don't see whether this will be a regular review. How frequent will this review be? In paragraph 6 of the government's paper, it mentions that there was a review in 2012 and another one in 2016. So there was a biannual review. So the Bar Association would like to monitor these reviews, but how often will they be conducted? Especially in the previous year, we have some young barristers there. We've done a comprehensive survey regarding their work and income. So it is not attractive to criminal work is not attractive to young barristers because of remuneration levels, and a lot of times the barristers, when they operate their practice, because of high rents, they cannot take up a lot of criminal cases. So on this occasion, if we have young barristers who wish to undertake criminal work, this would be an incentive for them. So aside from that, the Bar Association welcomes this adjustment. Okay, thank you, Mr. Randy Sheck. Next, Mr. Stephen Hong from the Law Society. The Law Society welcomes this adjustment, and I'm also very happy to report to Chairman that we've only had 2 discussions because in this adjustment, the work the government did was actually very down to earth. And if you, they also heard from the Law Society and Bar Association. So our 2 bodies agree. I have to thank the HAB, the legal aid department, where we came to a conclusion very quickly, and the industry benefits from it. So I hope in the upcoming criminal legal aid remuneration discussion, we can adopt this methodology, and where we don't need to spend a lot of time and reach a consensus. Thank you, Chairman. Okay, so now it's Q&A. We have 3 members who wish to speak, 4 minutes each. Mr. Alvin Young. Thank you, Chairman. I need to declare I am eligible to work as a criminal duty lawyer. I support the review and I support the increase, but I want to follow up on paragraph 10. The government wishes to introduce a mechanism for review. So do we have a mechanism? Do we have a draft? When will the government introduce the mechanism, and what kind of mechanism will they use? Thank you, Chairman. If you look at the history, the criminal legal aid, they have irregular reviews in 92. The previous ones were 2012 and 2016. So in 2016, there was a review for barristers. There was an increase of 50%. The instructing solicitors was 25%, and at the district court, the increase was 40%, and so on. So for the DLS, does not have a regular review. To respond to Mr. Randishek's question, in paragraph 10, if there is a review of the criminal legal aid, we need to ensure that we do not neglect the DLS and LAD, because all the 3 parties are recruiting from the same pool. So the next criminal legal aid review, at this point, we don't have a regular schedule. Should it be every 2 or 3 years where we have a comprehensive review? Because as I said, the last implementation was 2016, and it changed the fee structure. So I think we will suggest we will look at the impact on criminal legal aid after the current adjustment. We will stay in touch with the Bar Association and the Law Society before we consider when we should do our next review. Well, Chairman, that is exactly not ideal, because let's say the duty lawyer scheme, you have an increase of 50-odd%. Of course, we welcome that, but the fact that you need a sudden increase, a sudden significant increase, means that there's no mechanism in place. As the Bar Association representative said just now, it doesn't attract people. Now that you've increased it, it might attract people, but then in 2-3 years' time, when it falls behind the market rates, we'll see people leaving the industry again. So the government should make up its mind. There should be a review every 2 or 3 years. The rates could go up or down. At least we need a mechanism. Will the government consider that? Chairman, I'll take note of Mr. Young's recommendation. Since 92, we set a mechanism where every 2 years we'll have a review in line with inflation, consumer price index C, to ensure that we can maintain market competitiveness. So if we include paragraph 10, when there's a review for criminal legal aid, at the same time we will also look at the duty lawyer scheme and LAD. I think this is a practical approach. Next, Mr. Holden Chow. Thank you. Just a minute. It's 6:25. I want to announce that if you don't disagree, in our first agenda item, we spent some more time. So I'd like to extend the meeting at the maximum to 7 o'clock. Next, we have Mr. Holden Chow. Thank you, Chairman. Well, of course, I welcome the review, and we have said that the duty lawyer scheme remuneration has not been able to catch up with the market rates. So I think I'm echoing a lot of views that there should be a mechanism. So when there is a review of criminal legal aid, they should have it on par with a DLS and LAD. So we don't want one to outrun the other. So I hope the government can adopt these views. So in your future mechanism, should it be every 2 years? We just want to ensure that the criminal legal aid and DLS can maintain parity, so that can achieve your stated policy. Mr. Dennis Kwok, the industry has fought for this for a long time, and finally we see this increase. In the past I mentioned that, and other colleagues had mentioned that can the DLS scheme be expanded to include people incarcerated in the police station and can cover, provide more services. Will the government consider this? Thank you, Chairman. So people incarcerated in police stations, whether and how we can provide legal services. The legal aid department had provided a recommendation when we were looking into it, but we need it covers a lot of areas. So the police, when they incarcerate a person, they have some operational needs. For example, when we have a mass arrest, how do we provide legal services to each individual, and is it feasible operational wise? And if you look at overseas experience, for example in Australia, the preliminary legal services, some of it can be provided by telephone, and we will be looking at it from this perspective, and if it's decided that we need to provide legal services to these people, then the DLS is a direction we will definitely investigate, because it seems that they are the appropriate and flexible service providers. But of course, the DLS, they have their own committee. The Bar Association and Law Society will supervise their work. If we take this direction, we'll have to consider this.
Okay.
Next, my turn. First of all, I welcome this proposal. We've been striving for the change for a long time. I just want to share this with you. We have 3 law schools in Hong Kong. I need to declare that I am teaching staff in the City University. Now, on the face of it, we have a lot of graduates of law schools, and on the face of it, there aren't sufficient jobs. However, it is difficult for young lawyers to join the field of criminal litigation. It's really a struggle for young graduates. It's challenging to join the criminal field, but it's really difficult to make a living. And to earn reputation in the field, one will have to struggle for many years. Duty lawyer service provides opportunities to so-called make ends meet for them, And whenever I bump into my former students in the street, I would often hear that it is really difficult to survive in this field. I would ask, well, why don't you become a solicitor instead? Now, these practitioners do have perseverance, so we need to be more encouraging. We need to compete with other fields of the legal sector. Sometimes we even have graduates leaving the field of legal profession altogether. So first of all, we should adjust the rate according to inflation, and for civil, commercial litigation, vis-a-vis criminal prosecution or criminal cases, well, the gap should not be so wide, because sometimes the predicament that we see in TV court drama is, after all, reality. It's really difficult for these law students to study PCLL. Even after they graduate, they need to gain practical experience, and we need policy support. I hope we can have reasonable fee adjustments so that for fresh blood in the profession, they can build their reputation. And when it comes to the criminal field, I hope that more can be done, because this is, after all, service for the public. As for the review period, I think that the comment is quite unanimous. Next, Mr. James Toll. Now, not many members are here, although I see a big team from the administration. There were many members just now, but let me reassure you that it is not because we are not concerned. Well, this paper is very much welcomed proposal. It's a fee hike. If it were the contrary, definitely the administration would be harshly criticized by members, especially since the last review was conducted back in 1992. So I hope the two legal professional bodies would not mind having only members who are also lawyers remaining here. Picking up on Mr. Dennis Kwok's point about arrestees in serious cases, I hope this can be considered first, because if you introduce the new policy en masse for all arrestees, it may be more problematic. Whereas for serious cases, because of the serious consequence, the service is very much needed. The length of imprisonment could be up to 10 years. And I think this will be acceptable by the public. Well, perhaps the law enforcement agencies do not welcome this proposal, but at least for serious cases, you need to implement this more expeditiously. That's the first point. Second point, say the whole day fee will be increased from 7,300 to 11,000. That looks a substantial increase. However, I still hear different comments about that being not attractive enough, and I have this question, and I'm not putting this question to the administration, rather Mr. Robert Pang, Senior Counsel, because you have the experience and you are part of the working group, and you act as a shield if you say, okay, this is okay. About this level of fee, what is the benchmark? In 1992, you may have a formula, but it's been so many years. So what is it benchmarked against back in 1992, so that we understand the survey and how you have come by this level of fee, because I suppose you are the most experienced member in your working group. So is there anything you would like to tell us frankly? Mr. James Toh, thank you. Of course, as barristers, we would want the fees to be adjusted even further so that there won't be such a big gap in terms of fees for criminal lawyer and civil lawyer. So that's a very good first step. As for the benchmark, it is very simple. We adjust the rate according to the legal aid counsel fees for criminal cases. There is no extensive survey or vast information available. We are trying to catch up with the rate of increase for the previous one. We have completed this item because all our guests are here. We should very quickly move on to the next item because this is also something that we would like to discuss. That is biennial review of criminal legal aid fees, prosecution fees, duty lawyer fees, CB bracket 4452/1819 bracket 08 and 07. Members who wish to speak, please press the button. Let's start with Mr. Dennis Kwok, but let's invite the administration to walk us through the paper first. Thank you, Madam Chair. About that paper, may I ask whether the panel agrees that this will be implemented on the 1st of April this year? Now, this is a biennial review following the mechanism laid down in 1992, and that the fees will be adjusted, taking into account changes in the CPIC. So this proposal is based on the mechanism. As I mentioned in the previous exercise, the mechanism was established in 1992, and on a biennial basis, we would review the three fee categories, or three fees. And at the time, we also considered whether there were difficulties in briefing counsel or solicitors. There no difficulties been identified. So in this exercise, we're going to make reference to the changes in the CPIC between 2016-17 and 2017-18. According to the CNSD, the CPIC change was 4%, so the fees will be adjusted upwards by 4%. And we also explained the way forward in paragraph 13 because this proposal covers three fees. If we are to adjust the criminal legal aid fees and prosecution fees, we need to amend the legislation by negative vetting. This is for criminal legal aid fees. As for the other two fees, prosecution fees and judicial lawyer fees, the change can be implemented administratively. Well, as this proposal entails three fees altogether, once we have the endorsement of the panel, we will amend the legislation, and then we will get endorsement from the committee. And once there is commencement of the notice relating to criminal legal aid fees, we'll also introduce administrative adjustment for prosecution fees and judicial fees. So let's invite the representatives of the Bar Association who would take the floor. Mr. Shack. Similarly, like the previous paper, the Bar Association welcomes the proposed increase. As Ms. Choi put it, this is a biennial adjustment exercise. Our observation is that we understand the increase is pegged to the CPIC changes. Our members are concerned whether CPIC is the suitable reference because, say, for professional legal practitioners, apart from price changes, they also need to consider other issues, especially for young legal practitioners. They may need to shoulder a substantial rent hike, and every 3 years the rent may go up by 30% or even more. So for a new entrant, especially a criminal lawyer, they need to take care of the substantial overheads, and the increase in overheads far exceeds the increase in fees, and the gap will continue to increase, such that we'll see something similar to the previous paper. There'll be a substantial increase comparing to the 1992 rate. We need to consider whether CPIC is a suitable reference. Next, Mr. Stephen Hong from Law Society of Hong Kong. Thank you, Madam Chair. I don't know whether it's I'm fortunate or not. I have been taking part in the discussion of criminal legal aid fees since 2006. Well, now the discussion is very smooth, but at the outset I did ask the government why fees charged by criminal legal aid lawyers were far lower than lawyers in civil legal aid cases. So far I haven't heard any acceptable explanation, but as I said, the discussion is now more open and more pragmatic. I am not really happy with the proposed increase. I believe there is still room to adjust upwards, as we have a new taxation rate last year. For a while, the government said that we have a taxation rate of $4,000 an hour. But with this upward adjustment of the taxation rate, I think there is all the more reason for the government to reconsider the fees payable to criminal legal aid lawyers. Another point is, apart from the although we have a biennial review system, fees will not be adjusted until completion of the biennial review, which is the following year. If I remember correctly, we haven't even started discussion about the proposed increase for 2018. Well, we need to discuss it this year. No matter the proposal, the actual increase won't be implemented until 2020. So you are really getting away from reality. I agree with members that you should set a time frame for such a discussion. Thank you. Next, Mr. Dennis Kwok. Madam Chair, of course I support this proposed increase. We hope that the proposal can be implemented as soon as possible. Next month we'll be meeting the CSOA on this issue raised in the policy address of the Chief Executive, that is to widen the scope of service of legal aid, and together with the two legal professional bodies, we'll be meeting the CSOA. By then, I hope that some long-standing issues can be discussed together with our policy suggestions. But before that, I hope the administration would listen to the views of the two legal professional bodies and see if you can give a response so that next month's meeting will be smooth.
And I also want to thank Legal Aid Department. They have been very professional and contributed significantly. Thank you. Do you need a response? No? It's my turn. There are a few points I wish to make. First, we would like to see a better job done with legal aid, and as long as resources are used efficiently, everybody feels that legal aid is very important to the Hong Kong public, especially the middle class. The grassroots have easier access. The richest don't need legal aid, but to the middle class, they have the impression that they don't have the resources to seek justice. So with the adjustment, that gives people better access. And there are two bottlenecks. I feel the Hong Kong government, we want to encourage Hong Kong people to work on the mainland, to retire. And when they have they might have less legal disputes, but in developing a career, there are different legal regimes, especially when you talk about criminal cases. I would like, when possible, could we have some breakthrough, for example, Hong Kong permanent residents living in the mainland, if they encounter criminal proceedings, then can our legal aid framework be designed to extend some assistance to these people? I don't mean that it can help them with the court cases, but at least we now have a lot of volunteer workers. But if you don't have that networking, they are left to their own devices. They are in the mainland and they are not familiar with the system. So that's one point I want to raise. The second, in passing, I just want to say that legal aid is a very slow process. I need to declare. Sometimes I provide expert advice, and I've done so for a few years. I don't know what kind of excuse you can have for holding back on the fees. Some people, some firms, law firms, rely on this income, and I feel sorry for them. They have to pay salaries and so on, and but their fees are being held back for years. That needs to be reviewed, especially for small law firms. Well, you need to review that, otherwise we'll have to put it on the agenda for discussion. So I just want to raise two specific points. You need to review. I support that. Thank you. So let's see if Ms. Choi, is there anything you need to add? Thank you. Well, I think we will look into this. It's a policy issue. Legal aid doesn't cover mainland cases regarding lawyers' fees. A lot of times we can explain why the accounts have not been settled. Sometimes they have to wait for the case to end, because according to the legal aid ordinance, before the case ends, we cannot pay the full, we cannot settle the account, because there might be taxation costs, legal costs. But I have heard Chairman's concern. I also hear from my friends in the industry and the Bar Association and the Law Society. Yes, we look forward to a positive response. Mr. James Toh? Well, first, the outstanding accounts, well, I think we can have some interim billing. I think you need to look into that. I don't want to influence your decision, but the legal aid department will have to bear some risks, but you have more backing compared to small law firms. That's it. Second point, regarding overseas legal aid, we shouldn't be limited to the mainland. So as a policy, for example, let's say the Philippines, sometimes even the CE will intervene, but they but it's very difficult to raise fees. That's it. Third, Mr. Hong, the past president, he cannot be convinced why criminal legal aid rates are lower than civil legal aid. Now, let me share some information with you from some ex-officials, because the civil cases, the clients, or the cases are attractive. So the barristers, if they're attracted, then so if it's unattractive and nobody wants to take on civil cases, that is not satisfactory either. So that is what one ex-official told me. It seems that it has been considered, so I hope sometimes the government thinks along those lines. They say that they have no problem recruiting people in the criminal side. So, if the barristers can't take up these cases, what are they going to do? They can't drive a taxi. So that concludes that point. So coming back to CPI Index C, just now Mr. Randy Shek said, you are aware. The difficulty is rents. So you should have an element that is linked to rent, unless you say, we don't expect you to rent chambers in Central. You can operate in Starbucks, a home office, or an industrial building. You can even rent those office for rent, unless you change all the rules. But then that upsets everything. So otherwise, you shouldn't have a rental element. Those are actual expenses. So I've been repeating this over and over. So even though I'm not representing the Bar Association and Law Society, I still think I'm making a reasonable point. So as long the government seems to be of the view that you're not starving, you still have some income. Well, I don't think that is a correct line of thinking. So you should have a larger increment on the next occasion. Anything else to add? Let me highlight the difference. Thank you, Mr. To, for your question. Civil and criminal rates. It's not because that there will be people taking these jobs even if you offer a low rate. It's not just Hong Kong. There is this discrepancy in other jurisdictions as well, because civil cases attract higher rates because, according to the legal aid ordinance, if a case is won, the award is commensurate to taxation, but they don't have this privilege in criminal cases. So traditionally, the rates are lower than civil cases, and it's not just Hong Kong. This is the case for overseas jurisdictions as well. So, but I heard Mr. To's concerns. Well, I understand. I had anticipated your response. But if you were to rely on that response, and I have actually more to say, you're just saying that that's the case for overseas. Well, but overseas is overseas. They have their rationale, or their ecology is different. But in Hong Kong, if if there's an individual in Hong Kong working on the defense side, well, if there is a large discrepancy, I think that's a problem. I understand Mr. Dykes has something to add.
On our part, Mr. To's observations about as it were, the base for the calculation of fees and their increase has some merit. I wonder what was the original base on which they based the Consumer Price Index review, because if it's relates merely to consumer items, it's not an appropriate base. And I'm certainly interested to look at my profession and see what are the actual base costs that are required to operate a modest set of chambers and to be not in penury. Because I can say that there are some committed criminal barristers at the bar trying to make a living, but a recent report prepared by the Young Bar, which is you will get a copy in the next month or so, indicates that I think, and Mr. Sheck and Mr. Choi can tell me if I'm wrong, there's something like 15% of young barristers were operating at a loss. Now, I'm not expecting the legal aid to be a benevolent farm on which young practitioners can graze contentedly, but there is something wrong if you find that barristers, as I say, cannot make a living, having invested in their education, post-qualification experience, and then done pupillage. And I would ask the administration to consider seriously whether the base needs looking at again to be more realistic upon which to base subsequent increases.
Yeah. Okay. 洪律師。
多謝主席，好短嘅我仲。
A short response. Just now I heard the director. I've heard these responses over the years. I would say that a civil lawyer can charge more because the government can recover some of the costs, and in criminal cases it is a write-off, there's no return. So that means you're asking the lawyers to subsidize the whole system. So that is incorrect. So I hope I can persuade the director to change their thinking. Okay, because of time constraints, I agree with Mr. James To. Other overseas is overseas. We would want to attract talent to the industry and stay in the criminal field. It's very important in the administering of justice. It's exactly 7 o'clock. Thank you for attending. Thank you for your patience, allowing us to have a full discussion of the 3 agenda items. So I hope that you can participate more frequently, and thank you, everybody.